Welcome everyone. My name is Victor Gold. I'm Dean here at Loyola Law School, and it's my great pleasure to welcome you to our beautiful campus for today's Fidler Institute on Criminal Justice. A lot of people to thank. I'm going to begin, of course, with Judge Larry Fidler for lending your name. Thank you. Also, I want to thank all of the sponsors. They're all listed in our program who have helped support this, this terrific event. I want to thank all of you for attending. I want to tell you that you're going to have a great experience today. Our event staff does a wonderful job, and so I want to thank them. You'll see them around during the day. Of course, I also want to thank all of the speakers. This is a terrific program that has been assembled for you, and I used the passive voice because the last person I want to thank is the person who actually did it all, Professor Lori Levinson. If you're a law student, there isn't any professor who's more dedicated to you. And there's no lawyer more dedicated to improving the criminal justice system. And if you're a person, there's no one you want as a friend more than Lori Levinson. So it's my great pleasure to present to you the originator of this program, the chief cook and bottle washer, Professor Lori Levinson.
Thank you so much, Dean. First of all, there are seats up front. I want to make sure that people have seats. So if you're just walking in, just come on down. We'd love to have you. I promise to call on you first. There we go. Or as we say in my class, last call for a good time. If there are any other seats open next to you, please raise your hand. Any other seats open? Plenty. There's one over on the end there as well. So welcome everybody. I am delighted and honored to have you all here for our Fidler Institute. Something that we take great pride in. I want to thank the Dean so much for being supportive, Deanna Donini and Alicia Mejia and Hamid, everybody on the staff who has helped to put this together. I want to thank some students you're around. Raise your hand, students, who have been very helpful in putting things around. Most of them I threw into the overflow room. And of course, I want to thank Judge Fidler for being an inspiration and a great support. To our speakers, I love you all. And I realize I owe you all. So just let me know when I can come and do something for you, because today we are going to have a magnificent program. We're going to start off our Fidler Institute the way that we have a tradition of doing, which is the State of the Criminal Justice System address. And we start with our very own District Attorney, Steve Cooley. An introduction. How do you give an introduction to somebody who's a legend, so well known and so well respected in our community? He is a good friend of Loyola Law School and a real leader in our community. A 3-term district attorney, and I sure wish you might think about staying for more. Yeah. And I was thinking of some words that would really fit. And I would say innovative and courageous. He is a district attorney who has taken stances on difficult issues and tried to move things forward, whether it be 3 strikes or standards of integrity for district attorneys, many of whom are here today. And I want to recognize our friends from both the district attorney's office and from the public defender's office and from the general bar. So I'm going to call upon Mr. Cooley to give us the annual State of the Criminal Justice System remarks from the District Attorney's perspective. Please join me in welcoming Mr. Steve Cooley.
The state of the criminal justice system, I think we're in deep trouble. I think we are in the worst potential state of the criminal justice system in my nearly 4-decade career in that system. And that's because of AB 109, which upset a perfectly good, effective, logical system that was, through the work of prosecutors, police officers, defenders, and judges selecting individuals who truly deserved to be punished by way of incarceration. AB 109, which was apparently, at least arguably, motivated by the Plata decision, was the worst solution anyone could have come up with. A reasonable estimate is that 25,000 individuals who would have ordinarily, properly been sent to state prison for an appropriate amount of time are not going to be going to state prison. They're going to have to do their time in some sort of local custodial setting, and by custody, it could be virtual custody, ankle bracelet, things of that nature. We accomplished, the Imperial Collective we, something historic in the last decade. The lowest crime rate in 60 years. That is historic. The system was working. And a critical element to that system was incarceration or deterrence achieved by the threat of incarceration. Now, how are we going to respond to it? You cannot fix AB 109 legislatively. It can't be done. Not enough lipstick for that pig. There just isn't. It should probably be repealed. But is there the strength, the energy, the power for people to come together and sort of say, you know what, this was a horrible idea, passed in 5 hours, 527 pages, introduced, 5 hours later passed, no vetting, no legislative committees except for the joint budget legislative committee. No one thought this through. I'm predicting the greatest spike in the crime rate in our lifetimes, and it's starting already. There's going to be officer-involved shootings, there's going to be more burglaries, there's going to be more murder, there's going to be more rape, there's going to be more fraud, and we are going to be a very busy profession, working very hard to process this new increased workload and achieving much less in terms of the ultimate result. Now that, I hope doesn't steal any thunder from the AB 109 panel this morning, but that's where we are. We accomplished something great, and it was destroyed with a signature by the governor for all the wrong reasons. Now, that's sort of the bad news. Let's talk about the good news. We're here at the Fidler Institute. Look at all the panels, the people in the panels. These are all distinguished people, and every panel has a prosecutorial, defense, judicial component. These are top-notch people. These are important, timely topics. You're lucky to be here, and I commend you to have a great day because the program is, once again, terrific. And by coming together, the different components of the criminal justice system, we will come up with a very good product. It's not just prosecutors, not just defenders, not just judges, not just academicians. It's all of us working together. And we have a very good system right now because we have worked together. So have a great day.
We talked briefly about the best way to provide you an overview, both historically and substantively, of what we call realignment. And we realized that any one of us could stand up here and probably talk for an hour and just get the conversation started. And we've got a total of an hour to present this to you. So what I'm going to do is give you a very short historical and substantive overview. And then we'll have a presentation from Albert Camacho from the Public Defender's Office, and then from Craig St. Pierre, and then Kurt and I will take any questions that anybody has. And you're going to make a policy statement overview?
Yeah, an overview.
Okay. So it's hard to decide how far back to go to set this legislation in context. But I liked a background piece that I read in the Met News. And what I did is I actually took 3 or 4 news articles, sort of set the the scope, and they all came out in about May of 2011. So the Met News of May 25, 2011 said historically the record of the late 70s is an era of pivotal socioeconomic change in California. A new wave of international migration, a shift from an industrial to a post-industrial economy, and a new baby boom. Now, why am I going back to the 1970s? By happenstance, Jerry Brown was governor at this time. And this socioeconomic tsunami crashed into California and played a central role in its political processes. The crime issue was especially vexing for Governor Brown. A longtime opponent of capital punishment, he responded by signing a dozen or dozens of lock-em-up crime bills. Not surprisingly, the new laws and tougher attitudes by prosecutors and judges began raising the prison population. When Brown became governor, the state had 20,000 men and women behind bars and hadn't built a new prison in many years. By the end of his governorship, however, prisons were packed and corrections officials were begging for new space. Brown supported this reluctantly, and a $495 million bond was passed to jumpstart prison construction. During the 80s and 90s, billions of dollars were spent on new prisons. The Department of Corrections mushroomed into a huge state agency, tens of thousands of employees. California Correctional Peace Officers Association became a very powerful political tool. However, expansion of the prisons lagged later on, and right now it's 79% more inmates than design capacity for prisons. By the time Governor Brown left office, there were 100,000 people in prison. It finally leveled off later on about 150,000. And overcrowding generated lawsuits, and I'm going to talk about that in 1 second. The next article I read was May 27, 2011 from the Daily News, and it said, in 1994, 3 strikes was passed. And they gave a bunch of statistics, and the statistics were as follows. In 1980, there were 24,200 arrests for felonies of people over the age of 40. By 2009, there were 110,000 arrests for felonies for people the age of 40. And by 2009, there were 8,700 prisoners serving life sentences under the 3 strikes law. Cost $1.8 million to incarcerate a person from age 43 to age 82. The estimate was it would cost $10 billion to house the current 3 strikes population over the next 25 years. Then, of course, comes the U.S. Supreme Court case. And the U.S. Supreme Court said, you know, California, your prisons are real crowded, and you have to shift your prisoners out of your jails or build more jails. And they thought that Jerry Brown's transfer idea of realignment would solve this problem. And so there was a long discussion, but I actually wanted to talk about 2 articles before I get into that. This article was entitled "No Easy Fix for State Prison Crisis." It was dated May 25th, 2011. This was the LA Times. And this highlights the points of views. Loyola law professor Lori Levinson, a former federal prosecutor and veteran criminal law scholar, points out the high recidivism rate and past cuts in funding for prison rehabilitation and education programs as a formula for continued, even worse overcrowding. We have to stop the insanity of sending nonviolent drug offenders and low-level theft offenders to prison for life, Levinson said. Nobody is saying we should let murderers out. We have to stop the revolving door. In the dissent in the U.S. Supreme Court case, was Rutherford, I think his name, Justice Alito said, sending more inmates to prison has led to lower crime in California and elsewhere. From 1992 to 2009, violent crime rate has dropped 58% in California. and the violent crime rate fell by 43% nationwide during that same period. Releasing inmates early, as some officials say may be necessary in California to meet the court's demands, will lead to an increase in crime. So what I think I've done is highlight the different views that are around. And then, of course, in their 5-4 decision, they ordered the people to be released. Now, you know that case, let me back up a little bit. That case that I'm talking about in California started with a lawsuit about, and you probably all remember this, about medical care in the prisons. And when that case came down, they said, you know, the medical care is so bad, we're gonna appoint a receiver, and he's gonna take care of medical care. And I think it was a doctor, I can't remember for sure. But he was appointed as a receiver to make sure that they got proper medical care. And the case went to a 3-judge panel, and there were 2 lawsuits out there, and they were combined into one lawsuit. And the 3-judge panel finally made a ruling. Since overcrowding was the primary cause of substandard care meted out to inmates, they ordered the state to reduce its prison population by between 38,000 and 46,000 people. Governor Schwarzenegger at the time appealed this, and that was what resulted years later in the Supreme Court coming down with a ruling saying, empty out your prisons, they're too full. So these articles sort of set the tone for the discussions that were going on when Governor Brown and his legislature are looking at multi-billion-dollar budget deficits, which they still are. So the legislature was introducing a bill, AB 109. Now, I'm going to give you a quick history because this is very, very interesting. AB 109 was first introduced January 10th of 2011 as a spot bill. What that means, it was a placeholder put into as a budget trailer bill without any substantive statutory amendments, only a statement of the legislature's intent to amend the Budget Act. The bill was not amended to include the criminal justice realignment provisions until March 14th, 2011. Those changes were available for review on the Legislative Council's website on March 15. And it passed both houses on March 17th.
Wow.
I saw that when it first came out. It was 600 pages. Signed by the governor on April 4, and originally to become effective on July 1st of 2011. Nobody, and I mean nobody, had read this from cover to cover and understood it in the 48 hours that it took to dramatically change California's criminal justice scene. This is the biggest change in the criminal justice system in California's history. And can you imagine? It took 48 hours to go into effect. The effective date was moved to October 1st, 2011, when it was made clear by every single justice partner that the justice system would not be ready in 2 months to create an entirely new way of doing business with so many cases. And then people started to read this document and found out there were so many problems in it. So that on September 2nd, 2011, AB 117 made a number of clarifying, conforming, and technical amendments to the Criminal Justice Realignment Act. They are still ongoing. And I think all of us on this panel have had input on trying to correct things that are wrong with the Realignment Act. We haven't even seen yet what the courts of appeal will do with a number of these provisions. So in a nutshell, what does the Criminal Justice Realignment Act of 2011 do? It makes significant changes to sentencing, changes the definition of felony, makes significant changes to supervision of persons convicted of felonies, where and how they will serve their sentences. It shifts substantial parole responsibilities from the counties to the local courts. Quoting the legislature, criminal justice policies that rely on building and operating new prisons to address community safety concerns are not sustainable. So, County, it's now your burden. We'll shift the cost to you and say it's because you can do a better job and it's better for public safety. The new supervision and revocation schemes for low-level offenders have new names that will become part of the criminal law speak. In fact, those of us in the business are already using these. Post-release community supervision for non-non-nons. If you don't know what we're talking about, you will by the end of this panel. Non-violent, non-serious, non-sex offenders. Mandatory supervision under 1170H5B, aka split sentence. All of this means that effective July 1st, 2013, criminal courts in each county will be responsible for conducting revocation proceedings for 4 distinct categories of supervision: probation, mandatory supervision, post-release community supervision, and parole, each of which has their own procedural requirements. So that's a quick overview of how we got here and what the vision of realignment is, but of course the devil is in the details. So Albert, why don't you start talking about the devil?
Morning. As Judge Wesley said, the devil's in the details. All of us on the panel have been living with this legislation now for almost a year. And all of us in various contexts have given talks and presentations and lectures on this topic. And speaking personally, the general lecture that I give is 1 hour. I'm going to distill it down to about 10 minutes. So we're going to kind of fly through this. Realignment. When we talk about realignment, Judge Wesley talked about AB 109. There was also AB 117. There was also AB 1X17, AB 116, and AB 118. All of those pieces of legislation combined are about 800 mind-numbingly dull pages. To get it correct probably would take another 1,000 pages. And to make the corrections that a lot of us think need to be done, Lord knows how long this is going to take. But what specifically did realignment change? What realignment modifies is, first of all, where felons are housed while serving felony sentences. Traditionally, they have always been housed in state prison and state prison only. What realignment does is, in certain situations, which I will go through, some felons can be now serving their time in local county jails. Realignment also changes which agency supervises felons after they are released from prison. Traditionally, every felon that walked out of state prison was placed on parole, supervised by a parole agent. That is no longer the case. We now have parole. We now have a second program called post-release community supervision, where the agents, the supervising agency, is, in most cases and in most counties, the local probation department. In Los Angeles County, for instance, the probation department has a separate unit that will be supervising these releasees. All other aspects of what we refer to as felony sentencing, which for those of us that practice in it know how complex and convoluted it can be, all of those other aspects are unchanged by the legislation. Sentence length, collateral consequences, and most other facets are unaltered by realignment. So what does realignment really do? Once again, certain convicted felons will serve their sentence in county jail rather than state prison. Additionally, those inmates that serve their time in a county jail, when they get out, they are not supervised. Remember, when someone goes to prison and they're released, they're placed on parole. Anyone who does a sentence in county jail, subject to an exception which I will cover, they are not supervised. The moment they walk out, there is no one for them to report to. There are no services available to them. They are out free and clear. Felons released from prison are released on either parole or post-release community supervision. Craig St. Pierre will talk about post-release community supervision, how it's created, how it works. So let's go back a little bit. Let's go back to the beautiful world we had prior to October 1st of last year. When someone was being sentenced on a felony, the judge had two options. First, If the defendant was eligible for probation and the judge thought that the defendant was suitable for probation, the defendant could be placed on what we refer to as felony probation. Otherwise, he went to state prison. And I give an example, Penal Code Section 422, criminal threats. The language says, shall be punished by imprisonment in the state prison. That was the world we lived in prior to October 1st of last year. Now the world we live in. Once again, the judge has the option to sentence or place a defendant on probation if the defendant is eligible and if the court finds him suitable. However, what happens if the inmate or if the defendant is not going to be granted probation? Now, we have a category of felonies that are referred to as county jail felonies. Note the language that I showed you earlier, punishable by imprisonment in the state prison. This is what realignment does. It has taken certain charges, most of them what we refer to as lower level nonviolent felonies, and the language now says punishable pursuant by subdivision H of Penal Code Section 1170. That language means that this sentence, regardless of length, is going to be served in a county jail and not in state prison. However, state prison is still an option. In fact, more often than not, state prison is what the sentence is ultimately going to be. Once again, I use 422. The language still reads, even post-realignment, shall be punished by imprisonment in the state prison. So how do we know on any given case where the defendant is going to do his or her time on a sentence? We look to what the defendant is convicted of. What were the charges that the jury found the defendant guilty of, or what are the charges that the defendant pled to? Are they all county jail felonies exclusively? Are they all state prison felonies or exclusively? Or, as is the case with a lot of our clients that work in defense, one of each. They're convicted of a couple of state prison felonies, a couple of county jail felonies. What happens? Well, the law is actually fairly clear on this. If all of the felonies that the person is convicted of are county jail felonies, then he's eligible for a county jail sentence. If all of the charges are state prison felonies, then that person is going to go to state prison. If there's a mixture, the law says he goes to state prison. But you also have to look to the defendant's criminal history. Let's talk about a situation where a defendant is only convicted of what we refer to as a county jail felony. It looks like he should go and do his sentence in county jail. There are disqualifying factors that the court looks to in his criminal history, in his rap sheet. And if any of those factors are present, county jail is no longer an option. And the two main examples, which are found in Penal Code Section 1170 sub H sub 3, strike priors, serious or violent felonies. Also, Penal Code Section 290 registration, registering as a sex offender. So if we have a defendant who is convicted of what we refer to as a county jail felony and would appear to be going to county jail, if we look in the rap sheet and he has a strike prior, or if he's subject to registration under Penal Code Section 290, he's not going to county jail. He is going to state prison. Realignment does not affect him at all.
Is that even an unalleged strike prior?
Has to be alleged. But thanks for asking.
But if he doesn't admit it,
If it's alleged, that's a disqualifying factor.
as long as it's on his rap.
Why don't we take questions at the end so we can finish this presentation and go through the questions?
Okay.
You're the judge.
So how does the defendant end up in county jail under realignment? All the charges he's convicted of have to be county jail felonies. And he cannot have any disqualifying prior convictions. If those two conditions are met, then and only then does the defendant serve that sentence in county jail. Otherwise, he goes to prison. Just as if we were back prior to October 1st of 2011. Other sentencing issues. Everything else regarding felony sentencing, all of these complex issues that we deal with in felony sentencing, and those of us that practice, we've seen the handbooks on felony sentencing. They're nice and thick and really complex. All of those are unaffected. What we refer to as sentencing triads are unchanged. For those that don't practice criminal defense law, most charges have a sentencing triad. And the classic example is low term is 16 months, mid term is 2 years, high term is 3 years in state prison. There are triads that say 2, 3, and 5, and they can rise up very quickly depending on the severity of the offense. Realignment didn't touch any of those. A charge that was a 16-month, 2-year, or 3-year sentence last year remains the same now. Realignment did not change what the sentence length would be. It did not change the percentage of the sentence that someone must serve in custody. None of those numbers have been altered. The way you calculate a maximum sentence is unchanged. Other sentencing alternatives, such as diversion, deferred entry of judgment, Prop 36, women's reentry court. There are all sorts of sentencing alternatives in felony practice. None of those have been altered by realignment. Now, funding is an issue, but that is a completely different kettle of fish. Supervision after release. What happens to someone who is released from state prison? Traditionally, they were released on parole. Now, however, there's going to be a subsection, a subset of inmates that are released from prison that are not going to be released on parole. They are going to be released on post-release community supervision. Craig St. Pierre will talk about the criteria for each. If a defendant is released from county jail, however, there is no supervision. This is a major change. For the first time in recorded state history, we now have a situation where people that are doing a felony sentence walk out and are unsupervised. This is a major change that realignment does bring. There is an exception, however. Judge Wesley referred to Penal Code Section 1170 sub H sub 5. It is referred to as the split sentence. To describe a split sentence would take about a half hour. It's exceedingly complex, and at least in LA County, doesn't seem to be used very much. So, to recap, what realignment modifies is the physical location where a defendant serves his felony sentence. Instead of it being state prison exclusively, we now have situations where they can serve that exact length of time in a county jail setting. And what realignment also modifies is how felons are supervised after release from prison. Some will be supervised by the state, some will be supervised by the county, and some will not be supervised at all. Realignment doesn't modify length of sentence or percentage of sentence that's being done, and it does not modify collateral consequences of felony convictions. That's realignment in about 10 minutes.
So, some devils in the details. Craig St. Pierre, I think you're going to describe the parole revocation aspect.
I'm going to try. Thank you very much, Professor Levinson. Good morning, everybody. Let me try to lighten up the room just a little bit because it's kind of a heavy topic. For those of you in the overflow room who are law students, I was a late entrant to today's proceedings, so you won't read my superlative biography, even if I had one, okay? But trust me, one day, if there is ever an Institute for Mediocre Law School Performance, it will be named after me, okay? Couple other things. Program note, the reason I was a late entrant, and so that's why the materials regarding AB 109, an FAQ that's been included in your materials, and also a glossary is not stapled to your otherwise beautiful manual, all right? That FAQ was prepared for a seminar that I delivered this past Saturday to DAs, to the DA's office. And so it's a little prosecution-centric, but in it we tried to address all the questions that I've been getting from my office in the last, well, since October 1st of last year. And I hope that it addresses some or all of your questions, but if it doesn't, please see question number 25, which invites not only DAs, but any and all of the legal community to give us a call, and we'll certainly try and answer any questions you have to the best of our abilities. And if I can't answer it, I'll just tell you I can't answer it, because as Judge Wesley said, and Albert just said, there's a lot of murkiness out there that has yet to be defined by appellate courts, legislatures, and people like us. You may notice on the pagination, by the way, that the FAQ goes through page 1 through 8, and the glossary start, or 1 through 7, and I think the glossary goes pages 8 through 12. That's because they're meant to go together. Okay, so you can stick them in some binder somewhere, put it on your shelf, and you'll always have it there for you if you need it.
And does anybody need copies of those additional handouts? We'll have them brought in. So.
Also, you know, I don't want anyone to think that when Mr. Cooley, well, Mr. Cooley has extremely strong opinions on AB 109 and its likelihood of success or lack thereof.
No.
No, it's hard to believe, in case you couldn't pick that up from his comments. But one thing he did that was, he had the foresight to know that this is what we have right now, this is the way the wind is blowing, and so he established something called the Parole Revocation Section, and he asked me if I might be the deputy in charge of this little section in our office that deals purely with the revocation portion of AB 109. And lest you think he told me to charge off like Audie Murphy into a hailstorm of bullets on some suicide mission, he really didn't. Okay, he actually encouraged this to succeed, but is realistic about the chances of success. And so with that, let me talk to you a little bit about the new county parole revocation system and a little bit about how it works. One thing that Albert mentioned was there are 4 new types of supervision. There's probation, same old probation you always had, no changes. There's mandatory supervision, which is essentially a glorified form of probation born upon the back of a split sentence. Please understand, those 2 types of supervision, when there's a violation, do not come into the revocation system. They go back to the sentencing judge. The sentencing judge has the complete authority to handle the sentencing in those 2 types of violations. All right. What I want to talk about today is the revocation side, and that pertains to the 2 other forms of supervision: traditional, what I call traditional parole, which Albert talked about, and PRCS, post-release community supervision. Now, what did AB 109 do with regard to this revocation system? Well, first of all, it transferred almost the entire revocation system that used to be a state system. I mean, there's a Board of Parole hearings that is still in existence, will continue to exist until about July 1st of next year, that was the sort of judge for parole violations, and it's still in effect. If you go over to the county jail right now and you drive all the way to the back, there's a parole hearing rooms there in the belly of the county jail. And there are, to this day right now, parole revocation hearings going on, conducted by the Board of Parole Hearings, with state parole agents bringing those cases to the Board of Parole Hearings. And like I said, that's going to go on until July 1st of next year. Then the BPH is largely going to phase out. They're going to have maintained jurisdiction over certain types of life inmates, essentially murderers, but that's going to be about it. The state parole agents who supervise those parolees will continue to supervise parolees, but in a very new relationship, they will now bring their cases into the county system, and we're working on how they're going to do that. But just to understand, AB 109 transferred the entire state parole system more or less to the counties. It did it in 2 phases. The first phase started on October 1st of last year, and that's with a particular type of post-conviction, post-prison inmate on a new form of supervision called post-release community supervision. Okay, post-release community supervision. The second phase begins next July 1st, as I said, when the people who remain on parole will also become county property. What are these people called? As I said, parolees continue to be called parolees. I use the term traditional parolees, but they're parolees. In the county, we sort of stumbled around trying to figure out what to call these guys for a while, and finally the nomenclature has settled upon the term PSP, which means post-release supervised person. Okay, so when we're in court addressing someone who's in a revocation proceeding, we refer to them as the supervised person. People who are on post-release community supervision go by the acronym PRCS, or post-release community supervision goes by that acronym. So if you encounter it in your practice, that's what it is. PRCS is post-release community supervision. It's a person who's gotten out of state prison and who's met the criteria to be released as a PSP. I'll tell you what that criteria is right now. Who are these people? The decision that CDCR makes when they have someone in custody and saying, okay, I got Joe in front of me and he's going to be either a parolee or a PSP. They looked at Penal Code Section 3000.08. The criteria is very straightforward. There are 5 criteria that determine whether or not someone will remain a parolee. Everybody else is a PSP, okay? The 5 criteria are, and mind you, when they make this determination, the statute only requires they look at the most recent commitment offense. They do not have to consider prior criminality. This has made a lot of people angry because initially this was billed as these are non-violent offenders, and everyone thought, well, we're just going to get a bunch of car thieves, and those guys aren't that hard to supervise. For example, Supervisor Antonovich, I think, in the county has submitted some legislation to change this piece. But it's important for you to know that the people who are coming down as PSPs, because CDCR does not have to consider their prior criminality, many of them have strikes. Many of them have prior serious or violent felony convictions. So to a prosecutor's mind, they are not non-serious, non-violent. And we just don't look at them that way, okay? But that's the way the statute right now requires the CDCR to look at them, and that's what they do. So if a person goes up to state prison on a serious felony, a residential burglary, he'll come out on parole. Goes up on a robbery, a violent felony, come out on parole. Gets paroled from a real third strike sentence. I'm not even sure there are any of these guys, but I think they're coming. They will come out on parole. If someone is classified while in state prison as a high-risk sex offender, which is not the same as the 1170H criteria, by the way, of is the person required to register as a 290 registrant. If they are a high-risk sex offender, and that determination is made by CDCR, the state prison system, based upon a risk assessment test called the static 99. If they get a high enough static 99 score, they'll come out as a parolee. But if not, they're coming out as a PSP. So we are getting lots of people who are sex registrants as PSPs. That may come as news to some people. And finally, if a person is determined to be a mentally disordered offender requiring Department of Mental Health Services, etc., they are also coming out on parole. So those are the 5 criteria right there. You can read them for yourself. They're referenced in my materials, but that's how the decision is made. How many are there? Let me just give you some quick numbers, and then I'm almost done. Right now, they're being released from state prison into LA County at a rate of 1,000 per month, and that number is holding pretty true. So right now, we've got about 7,000 PSPs in Los Angeles County. The anticipated number that they expect to have before it sort of maxes out and then begins to drop precipitously is 15,000. Probation thinks that it will ultimately level off somewhere between 5,000 and 8,000. I don't know how they get to that number. The number sounds a little high to me, but nonetheless, that's the pattern you're going to see. Up, 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 down, and then some leveling off. If the legislation goes through that has been submitted that will require CDCR to consider past criminality, that all these people who sort of are in this loophole section will come out as parolees, all right? And that will change those numbers a little bit. Now, right now, our office keeps track of how many PSPs are presented to our office anywhere in Los Angeles County for filing consideration for any reason, felony, misdemeanor, what have you, rejects, everything. It all gets entered into an in-house system we call PIMS. Right now, just last week, we crested the 1,000 number, so we've had 1,000 cases presented to our office for filing consideration in some fashion. Not all of them got filed, but that's how many have been presented for filing. That doesn't include the other prosecutorial agencies in LA County, city attorneys and the U.S. attorney. So that just gives you an idea of the numbers we're talking about. There are over 350 warrants in the system. Parolees. As of last week, there were, at its maximum, we had about 30,000 parolees in LA County. Right, as of last week, we had about 25,700. The number's coming down, 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 down. Ultimately, in 2017, we're expecting to have 8,000 parolees in Los Angeles County, 30,000 statewide. So the number we previously had in Los Angeles County will be the statewide number of parolees in the entire state of California. This is a very interesting number, particularly because if you read the preamble to the statute, one of the things it very clearly says is it is not the intention of this law to alleviate state prison overcrowding. If I were a cynical prosecutor, I would think that perhaps that was some creative lawmaking. Who knows? Differences and similarities between these two populations. Obviously, two differences. The first difference is their commitment offense, because that determines right now who gets released on parole and/or PRCS. The second difference is who supervises them. Parolees continue to be supervised by parolees, so that's no change. But the PRCS crowd now gets supervised locally by the Department of Probation. That's a big change, right? Because probation for the first time will be supervising a post-prison population. It poses some very unique challenges. Let's just say that. I mean, of these numbers that I've given you, the 7,000 number, almost the reality is that probation is still kind of getting up to speed in the supervision department. And so because of that, that 7,000 number has largely been, I don't want to get in trouble for saying something like this, but they've largely been sort of unsupervised. I mean, because people were trying to get up to speed the supervision element in probation. And so they haven't received any of the wonderful services they're supposed to get to prevent them from being recidivist offenders, and thus, here they come. But probation is now in charge of supervising the PRCS population. The other big challenge for them is that, you know, when they come out of state prison, probation classifies them high, medium, and low risk. And a high-risk caseload can be something like 150 PSPs, and you have to see them 3 times a month, twice in the office, once in the field. That's a challenge for a probation officer, because once these guys start getting into the violation system, you have to track violations, you have to be in court, you have to write reports, you have to do all that stuff, in addition to be a sort of magician and wave your magic wand over this PSP to prevent that person from becoming a recidivist, and hopefully to help them to reintegrate meaningfully back into the community. It is a tall order that's been given to the Department of Probation, and I think that's some of the reasons for my boss's cynicism with regard to the effectiveness of this statute. Well, I think I've gone on long enough for 10 minutes, so thank you very much. Appreciate it.
I'm going to ask Kurt Hazel to give some of his observations and the issues that it raises for him, and then I'm going to open it up to all of you, the judges, the lawyers, and the like, to ask some questions about how this works, and I'll ask questions as well.
Okay, I'm going to touch on some numbers too. First of all, let's take the number 10. 10 is the number of people who have been sentenced to county jail for 20 years or more under the new system since October. Let's take another number. 4,300. That's 22% of the county jail population that are the new sentenced prisoners that before October were 0%. Let's take some other numbers. 51,000 and 37,000. 51,000 is the number of felony convictions obtained by the LA County DA's office in 2009. Next year it went down to about 48,000, and next year down a few more. The 37,000 is the number of people who got felony convictions and were sent to probation with maybe county jail time. Who's left? The 14,000 that went to state prison. For many reasons, we believe the focus on realignment is in the wrong place. Why? Let's start with the group that is now being sent to county jail. Of the 15,000 under the new system, and I can give you the number for each year that plays out, but since this is so new, we don't have the final numbers, roughly a third or so are now going to serve their time in county jail. What is there about this group? This is a group that judges, or as a result of plea bargains with the judges okay, have all agreed should not be out on probation. They should be in custody. Why? Because of the purposes of incarceration in the penal code and case law are threefold: punishment, deterrence of others, and public safety. Every one of those people in that group are people that are supposed to be incarcerated. Well, there's not going to be a problem if they just serve their time in county jail, right? Only if the county jail facilities can actually accommodate them. Will they be able to? The sheriff doesn't believe it. There's one institution that's been impacted more than all of the others in the legal system. And in my point of view, that institution is the sheriff's department, and the next group, by the way, is the judiciary, because their responsibilities have been expanded and their powers are reduced, and with certain shoes that may drop in the future, reduced even more. And I'll discuss those very briefly. And this obviously is less educational than what you got on either side and more editorial. Okay. The Realignment Act assumes that the jails will be too crowded or that alternative methods of handling these people that are sent to the jails will be imposed. The sheriff has the power to release them on programs and get credit and give them credit as though they were in custody. And immediately, that's what he started to do at first on ankle bracelets. I think that sent a ripple through the system, and as a result of all these meetings I've been attending, I'm learning a lot about the role of defense attorneys that I didn't fully appreciate before. And one of those roles is that they have less influence over their clients than I thought they did compared to fellow inmates. So if the rumor is out there that you can plead to an N3 and you'll hit the bricks real soon with an ankle bracelet, the pleas speed up as opposed to slowing down. And if the other rumor, which is no longer a rumor, that if you take a felony plea and you say, and the judge says you need to be off the streets as a condition of this 180 days, as a condition of this felony probation plea, and you're really only going to be in jail, what, 10% of that time? Or if it's a misdemeanor, on 60 days, 2 days? Then no matter what their counsel's telling them, these people are going to plead and get in the system because they think they're going to get out of the system. And I don't know if I'm accurate in that, but that's what I'm hearing in these meetings. So, changes in the system. Back to our numbers. The sheriff believes that they will fill up. What are they going to do? They're going to open beds where they can, but they're under enormous pressure. What's the pressure from? The lawsuits and disciplinary issues and control issues in old sections of the county jail. Every lawsuit that caused our state prisons to have to be emptied or reduced is going to fall now on the county jails. If we go back to my first number, 10, if we start piling up 100, 200 people that are serving a decade or more in county jail, then all of the needs pointed out in the lawsuit for medical care, training, all of that will be brought in lawsuits against the county jails, forcing them to put more people out under the authority allowed under realignment. There's another huge shoe that hasn't dropped. The range of people in county jail, and right now there's 17,400 in county jail, is two groups, those who have been convicted and those who are awaiting trial who haven't made bail. Realignment allows the Board of Supervisors in various counties to let the sheriff release people pending trial on electronic monitoring and give them credit as though they were in custody. Now, that's a really interesting shift in responsibility in our tripod system here. It used to be, and so far still is, the judiciary sets bail and conditions of release. If you switch that authority after a judge has had a hearing, and there's two people there representing each side, and decides what bail or conditions of release should be, and then you go to the county jail, and the jailer, who is under enormous pressure to empty his jails, gets to decide to undercut that and put the person out. That's an interesting shift in authority from an open system with a neutral officer changing to one with a vested interest to get people out on the street. Do I think this will happen? I know the sheriff believes it must happen, or he will not be able to control his population. There are some other interesting effects outside of the county of Los Angeles, too. For instance, I was talking to a DA from a small county that has several women's prisons in the county. Many of the crimes committed in prison now have to be served in county jail. In this particular county, if you're caught smuggling dope and you get a new felony conviction or whatever, there's an 8-month wait before you're allowed to come in and serve your new county jail time. Nobody's going to serve time on these new crimes. So there's the impact here in California, in LA, and then there's the statewide impact, where 100 new prisoners under N3 cripples that kind of system. So I don't believe that anything should tell us that given the resources we have, the lawsuits that are coming, that we're actually going to use the incarceration model for a group of people that judges have agreed should be incarcerated. Some other model is going to have to be used. This focus is in the wrong place. What were the numbers I gave you for 2009? 51,000, 37,000 felony probation. Shouldn't our focus be on the 37,000? Secondly, the premise is false. In the legislation, it said we are changing our current system because it has failed. They used one criteria only, recidivism. 70% of parolees violate within their 3 years. I guarantee you those numbers will go down. Well, why? First, because you've knocked parole down to maximum 1 year. Okay, there's 2 more years they can't violate. 3, you've set up a new system that Craig didn't have time to tell you about, with so many other steps you have to take before you violate them, that the numbers will go down. So the numbers will go down, but they will be false. I think the numbers we should watch are the number of filings and new crimes. For instance, this crime we've known has gone down during one of the worst recessions we've had in years and years. Despite the economic condition, crime has gone down. Yesterday I received a summary from the Sheriff's Department talking about contemplating plans for their future. There was a key line I caught in there, and I'm really interested in seeing the numbers that go behind it. And they say, due to the upscale, the increased numbers of property crimes, we anticipate more N3s in the future. We haven't had an uptake in property crimes or any kind of crimes in years. Since October, when this went into effect, we're now going to get our first uptake. Is there cause and effect? Will this play out in the future? It's a key element of realignment. Now, we have been on a downward trend for filings and for sending people to state prison, and it's a result of the fact that the current system cannot be called a failure if you judge it by the statistics of crime going down. It can be improved, but you cannot call it a failure based on the fact that one group goes back at a 70% rate. Yes, that group needs to be changed, but that does not mean the current system failed. Maybe it means law enforcement has gotten better in finding the right group of repeaters and getting them off the street frequently. That's kind of our premise on it. This will play out. There is no way that the county jails are going to be able to function as local prisons with the numbers they have coming.
But there's some questions to be asked both by you and I have some as well. So I know you were holding your questions. I want to go to the judge and to Mr. Camacho to get their response to what people from the DA say. And Judge, what additional concerns has it raised for the bench?
Well, there's a lot of different concerns that it's raised for the bench. Sentencing is extremely complex, and there aren't answers to all of the questions. I think you had Judge Cousins here talking to people, and there's tremendous problems trying to figure out what the sentence should be, especially if there's multiple counties involved, and multiple counts involved. And each one of these have things that aren't answered in the legislation. So the judges are sort of picking their way through a sentence, and again, we won't know the answer to these until they hit the Court of Appeals. We're only 6 months into this, really, from the operating standpoint. Are you
worried about the effect, though, on your bail decisions, as was suggested?
I'm not. I was at this meeting with Kurt where we discussed this, and Mr. Cooley was there also. The judges are going to sentence according to the law, and they're going to set bail according to the law and take into consideration the things that they're supposed to take into consideration. Once we set a bail, and if the person makes the bail, they're out. If they don't, they're in custody. Then it's an executive branch function. If the Board of Supervisors wants to approve the sheriff and letting them out, that he's going to let them out.
But that doesn't bother you that people that you thought weren't getting out will be getting out?
That's been happening for years.
And Mr. Camacho?
Well, that was actually the point I wanted to make. I've been practicing almost 18 years, and the first five years or so, my practice was exclusively in misdemeanors. And that was a common phenomenon in misdemeanors way back then, and my understanding is that that hasn't changed. I remember in misdemeanor practice, I would have somebody where the judge set bail at $50,000, and they beat me to the courtroom the next day. So the phenomenon of the sheriffs releasing people out on bail or cutting a sentence very, very short, we've been dealing with that for a really long time. So from where I'm sitting, I don't really see an appreciable difference.
I see a huge difference between felonies and misdemeanors. The sheriff is now seeking, or we're told is going to seek authority to decide on anyone with bail of $250,000 or less. Those are very serious crimes. Ultimately, under the law, it could be on any case except a capital case or a life case. So there's a huge difference in the two, in our opinion.
But right now, the board's reluctant to give him that authority, and he hasn't got that authority. But with respect to, we've been putting people on probation, giving them a year in custody, and finding out that they're on electronic monitoring, which we have no knowledge of. The sheriff does that on his own. And so that has been going on for years, just years. And so that's nothing new in the system. The jail's been overcrowded for a long time, has 20 or 22,000 beds. They can't use them all because they don't have staffing to use them all. Kurt said that's 17,400 right now. That's probably about the maximum they can take right now until they get additional funding.
Well, actually, the maximum custody, or the maximum number of beds I'm hearing the past couple of months has been about 19. So they've pretty much held steady the past few months, where they're about 2,000 under capacity.
But they have committed to shutting down at least 1,500
that's a question I want to
beds.
follow up on. Many of my students go on the jail tour of Penn Central Jail, an institution that everybody there should be shut down. So I'm just wondering how the dynamic is working inside the jail now, that you have both the pre-trial detainees, and then you also have the people who are being sentenced, and you have the correctional officers who already feel the heat. We're going to have a panel this afternoon on that. Any feedback on just how the change is with who's actually in those institutions?
Well, Kurt brings up a really interesting issue, the county jail grapevine, which is very strong, and I'm still surprised after all these years just how they get their information and how it gets passed from people that are behind bars. But I certainly get calls all the time from inmates in county jail that are reading articles in either the Daily Journal, the Met News, or the LA Times, and that are asking me, okay, what do these numbers mean? Am I going to get out early? And all I can tell them is, the information I have, which is, no, sir, you are not getting out early. But there is a really strong exchange of information amongst, the inmates that are awaiting trial and the inmates that are sentenced, because they're not segregated. They're all put together. So it's very common that you will have somebody who just got sentenced talking to somebody who's awaiting trial and giving them advice about what to say to the judge and what to say to the lawyer and what to hold out for.
Questions from people?
Let me just, one other problem that judges have with respect to sentencing, and this has been around for a while also. When you sentence somebody to jail and then they get released early by the sheriff, then they come back on a violation, and you send them to prison or you send them back to jail, you have to calculate their credits. And it's always been very difficult for us to know, we as a time period, I committed you on this date, this was supposed to be a release date. Now, if it's released early, we don't want to give them credit for time they haven't done. Kurt was bringing up the fact that if the sheriff gets the authority to release them, we set a bail, they're in custody on that bail, and the sheriff releases them on his own after getting permission from the board, they get custody credit.
And is that one of the things that people are pushing to change in the bill?
I think that is one of the things that they want to change. They also get custody credit on split sentences, where they're placed on probation and they're not in custody, and that's one of the reasons that split sentences are so disfavored. I have a figure here. There are only 30 split sentences for the month of March, and there were I think 900 or 1,000 sentences given. So they aren't very popular.
Jump in with questions here.
I was wondering if anyone had an opinion. I know we've been focusing on felonies, but since the local county jail already had pre-existing duty for misdemeanor custody, providing that deterrent to quality of life crimes and the minor crimes that result in felonies, how is that punishment deterrent going to be affected by the realignment.
May I chime in on that one? If I don't, you know, it's not. The,
Short
the
answer.
The problem is this, and this is one of the unintended consequences of a 700-page law. You'd think they could have accounted for every consequence known to humanity, but in 700 pages they missed this one, and it's this. One of the opportunities that this law has presented is it's allowed us now to work in an official capacity with city attorneys, because city attorneys prosecute tons and tons of misdemeanors in this county, and a lot of them are very concerned now because the reported rate percentage that people were doing in county jail was 20% of misdemeanors, but I read Chief Rambo from the Sheriff's Department was quoted in the newspaper last week as saying that number is now 15% and may go down as low as 10, and who knows from there. That's got a lot of city attorneys very concerned because quality of life crimes, you know, crimes that are committed in places where all of us live are getting short shrift under this system. People just are not doing any realistic time, and for various communities in Los Angeles County, that's a real problem, okay, because they're ultimately expecting, in fact, they already think that their misdemeanors are doing almost no time at all, and that's a little bit of a problem. Mind you, some misdemeanors are very serious, 273.5s, et cetera, and I understand the sheriffs have legal responsibilities to keep certain of those people longer, but this statute puts downward pressure on how long they keep misdemeanors, if they keep them at all. The second point I want to make, which is what Albert talked about, is this. You know, we've heard of state prison commitments to the county jail of 12 years. I mean, can you imagine 12 years of bad bean burritos and county jail? I mean, frankly, I think it's harder time than going to state prison. But that was not the intention of the statute, which was supposed to, quote, rehabilitate. And one of the real shortcomings of the statute is that the Sheriff's Department is not set up to handle some guy who's a state prison committee for 6 and 7 years. They don't get any of the services that they might get in a state prison, vocational training, drug treatment, etc. Instead, they just sort of sit and wait. So again, there's that problem in the law.
Other questions? Sir.
By its terms, AB 109 didn't modify the length of the percentage of sentence that's served of a felony sentencing. But functionally, do we have any idea what percentage of felony sentence people that are committed to county jail are actually serving?
The answer is, initially, the sheriff was putting people out. Right now, he says, right now, all N3s, the code we've used, are serving their full sentence. Right now, until he fills up.
And this has varied over the last 10 years. So if the jail's full, people are doing less time because he's picking and choosing who he's going to release. He has criteria, and he releases people to make sure he's got room for more people. So at any given, I mean, at one point in time, people were doing, I think, 25% of their time. And you asked me if judges were happy about it. No, they were not happy about it. Then they increased it. There were people that were reporting to jail, and they were saying, thank you very much, go home.
The number that's changing is a judge sentenced someone to probation with the condition that they serve 180 days or 30 days. That number is the number that's shrinking. The person right now being sent to county jail to serve their felony prison time is allegedly serving all of that time.
Okay, so I had a person sentenced to 13 years county jail a couple days ago, and that's a 50% crime. It was a trafficking, narcotics trafficking with a weight enhancement. And so he theoretically should serve like 6.5 years.
Correct.
Is he going to serve 6.5 years?
That's the mystery.
Right.
Let me ask you this.
I don't think we'll know the answer to that until this plays out because it's brand new.
Let me ask you this. If he doesn't, how soon will it be till he's in Mexico?
I mean, yeah. Two things. One, currently we have already had instances of people absconding to other states. We're, in the midst of bringing them back to California. But secondly, the issue of the sheriff's ability to release early really goes way back to 1978 at a federal court lawsuit, Rutherford, which is still being overseen. So various points in time over the years, the sheriff has the ability to release people early. So I guess the watchword for anybody is a sentence may not be what it portends to be. It's almost like Alice in Wonderland.
Or if to quote Inigo Montoya, that the word sentence doesn't mean what you think it means.
Yes. And Kurt, I have N3s that were sentenced in my court. They are walking in court on iterations now. One of them is a restitution issue. Of course, now we're litigating whether the court has jurisdiction over him because he's a state prison committee. But I do have guys that have been in state prison that are walking in court.
If the idea is that we need to rehabilitate people, then why would you take all of the new people sent to local prison and have no tail hanging over them at all? No parole, no guidance, no supervision.
So that leads me to my question. Okay. How are we going to fix it? Because if you're at the Fidler Institute, we don't stop with, boy, we have something broken. Got the smartest guys here, I need some ideas of what we should be doing.
What Kurt raised, I raised actually with the governor's office, and their answer was, don't worry about the tail. We're going to have programs provided, and these people will go to them. and I said, I guess your experience is different than mine. But the answer, I think, look, if the sheriff thinks he can rehabilitate people, if you talk to the sheriff, he has education programs in the jail, and he wants to use them. And he has told Mr. Cooley that, he's told me that. We've talked about this with him. He really,
long enough for them to be educated.
he thinks he can work with them. If you follow the reasoning of this whole legislation, they believe that if they resource the local community, that the local community can provide services. But the trouble is that they didn't set up that network before they put in place these new laws that put more people on the street.
And who will pay for all these new rehabilitation programs?
Well, that's dependent upon a certain ballot initiative, according to the governor.
No, I don't even think that ballot initiative would pay for this. And so those of us that were in the early meetings on this, we said, we'll never get enough money to do this, to do it the way they envision.
So do we go back to the old system? What do we do, Mr. Camacho?
Well, to kind of piggyback on Judge Wesley's point, if you read the legislation, and I'm just going to focus on post-release community supervision for a moment. If you read that particular set of sections, it gives the supervising agency, which is in LA County, the probation department, it gives them the authority to do so many things for someone who's released from prison. It gives them the ability to order mental health. It gives them the ability to make sure that they're getting the mental health services they need, to get education, to get job training, to fully rehabilitate, to fully become a contributing member of society. It's beautifully written legislation with one little problem. None of it is funded. The answer is we've got to find some way of funding it.
Well, there's a second problem. The number of N3s coming out of prison will decline in the future because they're not going to prison. They won't entirely go away for complicated reasons. All of the new N3s are not subject to any of these services. They cannot be compelled to go to any of them after they get out of county jail, even if you had the money.
You know, another problem it's having, it was an LA Times article a couple weeks back about how some of the vendors aren't getting paid from probation. And in between the lines of that article was the fact that those vendors are the same old vendors we've always been using who have established the current recidivism rate. There's no knock on them, but it's not as if, a whole bunch of great new recidivism preventers dropped in from the sky, okay? It didn't happen. It's the same old people doing the same old things. And if you read the statute, even all the intermediate sanctions that probation is supposed to use prior to actually putting someone in the revocation system are all stuff, mostly stuff that we've already done before. I'm not saying it can't be done better. I mean, God knows we all want to wave a magic wand over people and make them law-abiding citizens. But the reality is that no one's ready for this. It's all the same providers. It's the same stuff. It's electronic monitoring. It's various things like that. So,
So I'm going to go down the road, and if there are questions, raise your hand. But I want to find out actually what we can do.
Question.
Yeah.
Judge Wesley, can I be assigned to civil?
You mean you aren't already?
So going back to my question, one idea that you think could help us get out of this mess, or at least change the direction, fix things, blow it up, any ideas whatsoever? I'll start with you, Mr. Camacho. How do we make it better?
I'll say I have the Pollyanna view. I really do believe that you know, listening to Winston's discussion of viewing these people holistically, if we can treat our clients, if the money exists at some point that we can get mental health services, we can get job training, we can get education, that is the ultimate answer. I firmly believe that.
Mr. Attell.
Well, I'm not quite as optimistic, surprisingly enough. 25% of the people coming out of prison right now test dirty within 4 days. Are we going to do a better system here? I don't know. I will defer, because my title is Assistant DA, and down at the end of the table is Deputy DA, to my boss, and he says, blow it up. Go
And
back.
what would you replace it with?
We need to go back to the state serving its fundamental function of protecting the public by locking up people that judges say need to be incarcerated for more than the county year time.
And then how do we deal with the 70% recidivism rate for those felons?
I don't know the solution to that, but I know they are not a higher priority than the public they impact.
Judge Wesley.
Money. I mean, I'm being honest, money. If you want to provide services, if the public is satisfied that the way to solve this problem, and the legislature is satisfied that the way to solve this problem is by providing services to those people that are released, catching them early, having a program, staying with them till they're back on their feet. If that's the way that they want to do it, then they have to fund it. And they have to listen to the people in the system that know what they're talking about, because the legislators haven't practiced criminal law. And so they have to listen. There are so many changes that are being presented to them. Mental health is one of them. A lot of these people are mentally ill that get out. And there's no jurisdiction under 1368 for the court to take action, to get an expert appointed or anything like that, until a petition is filed. And then there's a question about whether or not 1368 even applies to parole hearings. There's all kinds of issues about who's going to do this. And I will just say, I said to the governor, you properly fund the courts. And no matter what you get, Kurt says the courts are heavily impacted. Look, we can do whatever they throw at us. We have wonderful judges. They know what they're doing. And as long as they properly fund the court, we can handle anything that's thrown at us.
So I'm curious, what was the governor's response
To when I said properly fund the court,
Yeah.
he said, oh, there's that.
So my other question would be for everyone here, who are the movers and shakers up in the legislature that we have to actually start moving and shaking on this issue?
You got to go talk
Name and names.
The Speaker of the House. You got to talk to Speaker Perez. You got to talk to Darrell Steinberg. I mean, these are the leaders up there that are saying that they believe this will work. I've talked to all of them. They believe this will work. Steve and I sat down with the governor for several hours. He really believes it's going to work, doesn't he, Steve? Or is this strictly a move for money?
And Mr. St. Pierre, your ideas.
All right, presuming it's not blown up, what I would do tomorrow if I could was, first of all, I'd change the sanction for a revocation, for a violation of revocation, right? Parole back before October 1st could give a parolee who violated 1 year flat time, meaning no credit. It's equivalent of a 2-year state prison sentence at halftime. That was very necessary to have because they had a problem called churning, which is a term that applies to how many times you see the same person, same parolee again and again and again. When they saw a person for the third and fourth time, they said, see you later, you're gone for a year, we'll see you in a year. They just kind of took them out of commission. We can't do that in our current system. So we're already seeing guys who are not only getting convicted of new cases, but we're also seeing guys who are on repeat revocation petitions. And there's nothing we can do. We really can't up the ante. So we give them these 30-day and 45-day sentences in the hope that when you come back, you're going to get 90 days. It's very deficient, and you can't do much with these guys. And therefore, parole used to have a settlement rate Parole used to settle 90% of their cases short of actual revocation hearing. Their settlement rate's gone to 95% because of the new sanction. Guys are just snapping up the lesser jail time. But our settlement rate in our system is probably 99%. We've done one actual evidentiary hearing in Los Angeles County so far, and we've done hundreds of these petitions already. And the reason is guys are hearing that time, they're saying, I take it. They don't even want to wait to have a hearing. So at the hearing, they'll be in longer than they would be if they took the deal. So it's a problem. The other thing I would do, which has been alluded to already, is for the guys who are getting, for the N3s who are getting these local state prison sentences, if you care about them and you care about actually trying to reform them, you got to put a supervision tail on these guys and make them subject to some services. Just letting them out after they've done their jail time is a disaster. All right, and so I would change that tomorrow. And then there's an inside baseball change I would make. DAs don't have the authority to charge right now as a current law currently exists. Judge Wesley has been instrumental in fashioning a new law that will bring this whole system within 1203.2 of the Penal Code, which many of you recognize as the current probation violations section Penal Code, so that parole violations, PRCS violations, mandatory supervision violations, and probation violations can all be handled the same way up and down the state. That's very necessary for certain law enforcement reasons when we want to try to establish a quote, parole hold on somebody who might pose a danger to the community.
Would you extend the period of parole? Right now, if they don't do anything wrong on community supervision for 6 months, probation can terminate. And if they don't do anything, if they don't terminate after 1 year, they must terminate. And instead of 3 years, so they have 6 months to a year maximum. Would you extend that?
Yes, and I'd be willing to admit, right now, if you have no violation that results in a custodial sanction, as a matter of law, you're released from PRCS after 1 year, period, automatic, all right. If they want to keep that, fine, but I would make it optional. I would say, look, let probation make the decision about whether or not this guy should remain under supervision. Most of these guys, if they're doing great under supervision, don't terminate them. Keep them on supervision for a little bit longer.
So I want to wrap things up. We have one last question.
Are you seeing any differences in the female population?
Good question.
I see Chief McSweeney here, and may have the figures, but I did see that there was a bulletin from the sheriffs yesterday, Assistant Sheriff Cecil Rambo, saying they're going to have to expand custody for females because they're getting more of them now. I don't know why. Maybe more females were in threes and would go to local custody now instead of state prison.
So we have lots of questions and lots of discussion to be had, and that's one of the purposes of the Fidler Institute. What I'd like to do now, though, is thank this wonderful first panel. That
was fun.
We're going to deal with high-tech surveillance of and we'll be spying on all of you.
Oh, okay.
I think there's some refreshments outside.
Craig, it was fun. Thank you. Yeah, thank you. No, it's nice that, I mean, the fact is you and I and Albert have been working on this stuff since the beginning, so it's really